Enrico? Uncles?
Good morning, Chair.
Oh, how are you?
I'm fine, thanks, Chair. Still very busy on your side, Chair.
Oh, I'm not busy. I just wanted to check if I'm audible.
Yes, Chair, I can hear you, Chair.
All right. Can you see the video or you can't see the video because of your
No, I can see Chair looks very, very nice today.
No, thank you.
Chair, I'm still busy with the funding application.
Oh, you will brief us. Just make it a
Yes,
point
Chair. I will
that
do the
time.
briefing later
Yeah.
today, Chair. Okay,
Yeah.
Chair.
Make it a point that everybody is briefed before,
Yes, Chair. I'll do
cancel
so.
other meetings because we have prioritized this one on Friday.
Okay, Chair. I'll do so, Chair. Thank
All
you,
right,
Chair.
Thank you. Thank you, Ba.
Recording in progress.
Good morning, Cash.
Good morning, Chairperson.
Yes, please indicate when members are collating so we can start the meeting.
We are correct at the moment, Chair. We still have 2 minutes left.
Okay. We just want to be on time. This third time, we need to practice time management.
Okay.
We have been on time since we started, Chairperson, with this term.
I know. Akere Zulu, we take terms as the refreshing. I know. I was just saying it, that it must be recorded, that we are always on time.
Noted, Chair.
Chairperson, we may start. The Minister is present, Chair.
All right. Thank you, Gershwin, and thank you, honorable members and members from the department who have joined us. Let's welcome as well the legal advisor from Parliament and as well state law advisors who have joined us in today's session. Members, today we note that SAPS hosted its National Police Commemoration Day and honored 27 officers killed in the line of duty in the past financial year. A total of 66 officers were killed in just 2 years, with the Eastern Cape recording the highest number of police officers killed in line of duty. We continue to encourage the interdepartmental working relations between the Department of Home Affairs and SAPS in fighting crime and ensuring effective border security within South Africa. We also note the department efforts to improve the rollout of identity documents by forming partnerships with banks and shops, but continue to encourage the department not to leave those living in the rural areas behind. The Immigration Amendment Bill today, we are here to receive our first presentation on the Immigration Amendment Bill 2024. By way of introduction, it is important to reflect on some of the main objectives of the Immigration Act 18 of 2002, which this bill seeks to amend. Key objective of its act to promote human rights culture in immigration control, facilitating and simplifying the issuance of permanent and temporary residences to those entitled to them, detecting and deporting illegal foreigners, preventing and deterring xenophobia within the department and within communities. We have seen increased incidents related to foreign nationals trying to access healthcare services in Gauteng and in other provinces, including pregnant women, and we have a duty to uphold our human rights commitment as enshrined in the Constitution as government departments and members of the public. Honorable members, ministers, and those who have joined us from the department, the current draft Immigration Amendment Bill before our committee seeks to amend the Immigration Act 2002 in line with constitutional court judgments to revise provisions relating to arrest and detention of illegal foreigners. for purposes of deportations and to align these provisions and constitutional principles. The bill should be seen in the broader process of the review of the white paper on citizenship, immigration and refugee protection. We would like the department to also speak to the time frame and process of the white paper so that the committee has an indication of time frames moving forward. The department will now present the bill to the committee together with an overview of the process undertaken by the Portfolio Committee on Home Affairs and the proposed amendment. Honorable members and those who have joined us on the platform, I know that all of us, we got all these documents that will be presented to us today. And it will be important, Minister, just to indicate that, just emphasize mostly on issues that you think that members can take as one of the importance of this particular immigration bill, because we got the document and we have learned as well about the roadshow till to date in terms of this immigration bill. The bill will soon be published and advertised for public comments. After the recess period, we'll then receive further briefings on the public comments and engage, deliberate further on this bill. So members, we know that tomorrow, NA will be taking through this report in the House for adoption. So all other processes will then unfold after tomorrow's day in terms of the advert to be out. But on other matters, we'll be briefed in terms of what needs to unfold based on our agenda today. With that being said, I want to officially open this meeting and welcome you, the Minister from Home Affairs, that always, when it's your department, you always come, and if you are not present, you send an apology. We want to appreciate that you understand that the executive is important in these particular meetings. With that being said, I want to as well send the message of condolences to Honorable Mokai, and I hope that they have buried their loved ones well, and we hope that we want to wish him well and the whole family. Gershwin, please take us through the apologies so that we can start with our meeting. With that being said, the meeting is officially opened, and thank you.
Thank you, Chairperson. Good morning, Chairperson, honourable members, Minister and officials. Chairperson, Honourable Gotzel has tendered an apology. He's currently in Germany. Honourable Machubeni has resigned from the committee, Chairperson, but her membership to the other committee is still pending, and the new member that's meant to replace her is also still pending. It's with the presiding officers at the moment. And then the Deputy Minister has apologized. Unforeseen circumstances came up, Chairperson. And then, as you've mentioned, Chair, Honourable Mokai is still on bereavement leave. Thank you, Chairperson.
Thank you, Gesh, and we want to wish Honourable Mokai well, because we know that every after bereavement, there's after effects, and I hope members will send their messages to the Honourable One to keep well. With that being said, and apologies noted, honourable members, I hope you have noted the apologies before us. And I just want to check, Gesh, has the new member joined the meeting or he hasn't joined the meeting?
No, Chairperson, he hasn't joined yet.
Okay, which is correct. No, thank you for that. I just want to say to you, just make follow up with regards to those administrative processes, so that at least we know that all parties are involved and as well part of our meetings. With that being said, I would now want to hand over to the Minister for a briefing by the Department of Home Affairs on the Immigration Amendment Bill, the 8B 2024. Over to you, Minister.
Thank you so much, Honourable Chair. I'm just going to quickly show my face. I know you appreciate that always, but I do have some spotty signals. So I will just indicate my identity here from a Home Affairs perspective, and then request to switch off the camera again. So I hope you can see it's me that's here. Thank you very much. Sorry, Chair, you're muted. Sorry, you're muted.
Saying I can see it's you. Just apologize that you are in the car.
Thank you. Yes, no, I've been rushing around this morning. My apologies, Chair. But yeah, very good to be with you again, as well as with the honourable members of this select committee. And you are correct that from our perspective, we always really appreciate the engagements with this committee. And today we have quite an important item to take the committee through. Chair, I think your introduction has touched on really the genesis of this particular amendment, which flows from two constitutional court judgments. And I think you've articulated really the purpose of this amendment well. I do just want to emphasize two particular points. The first one being that this amendment also introduces real clarity to the process of deportation, and I think that is something to be welcomed, where it creates a really clear ground rules for how these processes are supposed to unfold, not only for the Department of Home Affairs and its officials, but also for judicial officers, for magistrates and judges, when they assess these applications. It really creates that level of certainty for what factors to look at and to take into account. I also want to say that this is not new for the department. I think the team will indicate that, of course, these requirements have been in effect now for a number of years following these judgments. So I think the department is well versed in the implementation of these requirements. And I think we've already benefited from that increased level of certainty and clarity around what is expected in a deportation process. Chair, the other point I would emphasize is the one you made around the broader reform process. The revised white paper that we are currently working on is certainly part of this same process, and really introducing that level of clarity, that rule of law element into how these type of procedures are done. But obviously, the white paper goes far broader than this particular narrow amendment, if you will. And then, of course, all of the technological reforms that will assist us in having more effective immigration management, including deportation processes. I think one of the important things has been the use of the fingerprint verification, even when suspected illegal immigrants are arrested, as that really brings additional clarity and verifiability into that deportation process. So indeed, Chair, we are aligned on the fact that this is part of the broader reform process that is underway. It's certainly not the end of the journey. It is one element that comes through the courts to us today. But it is not new. The department is well versed in these requirements and their implementation, and it is something that assists us with the level of clarity to make sure that when we do deportations, we do them effectively and we do them in terms of the law, and that they can stand scrutiny through the judicial process. So, Chair, really from my side, that would be the contribution. Let me join the members in sending my condolences also to the honourable member who has lost family members, and sharing our thoughts with them at this time. But with that being said, then, Chair, very happy for the department to proceed. Thank you.
Okay, thank you, Minister, for your remarks, and would want to hand over now to Advocate Guam for the presentation. And Advocate, please note that we have the presentation. You see how the Minister has done, picking up on important issues of emphasis. So as you present as well, it will be important for you to do so that members can have more time for engagement. Over to you, sir. Advocate Guam. Members, am I audible?
Yes, Chair, you are audible. I'll
Yes,
follow up
Chair.
when find out where they are.
but there's no qualm here.
Home Affairs must deal with it. Minister, where's your person? Andre Guam? Advocate? I can see advocate on the list of people who have attended, but I'm not sure if he can hear us. Advocate Andre? Enrico, can you hear me?
If I can just ask someone from the department to
Yes.
Okay, I can see now.
please
for
reach out. Thank you.
It's
All
Andre.
right.
It's Advocate Malakate who will do the presentation from the department side.
Okay, no, thank you. Over to the advocate.
Good morning, Chair, and good morning to members of the Select Committee.
Advocate Malagate, it is important for you to show up, then request to switch off the video. Then, if permitted, you can continue.
Good morning. Good morning, Chair, and good morning to the members of the Select Committee. I was afraid that to show my face because I'm a little bit darker, that I fall within the ambit of the deportation processes here on the basis of color. Thank you so much. May I switch off the video?
You are out of order, advocate.
May I proceed to switch off the...
Chair, you are muted.
Advocate, I was saying to you, if you don't have challenges, you can keep the video on. But if you have connectivity challenges, then you are permitted to switch the video off. It's on condition, not automatic. So just indicate for record purposes if it's because of connectivity or you just feel that you are comfortable without the video.
Thank you, Chair. I am comfortable with the video. If I may proceed, I'm not too sure if the Secretariat would assist with beaming the presentation.
Yes, they will do. You can continue.
Thank you, Chair, and also through your guidance relating to following what the Minister, how he made his opening remark, I will also try to do so. Just to recap, Chair, and on the slide after background, slide on the background, just to indicate, Chair, that indeed this amendment bill follows the two constitutional court judgments. One was issued in June 2017, and the next one was issued in 2023. But primarily, the two judgments then found that Section 34 of the Immigration Act are unconstitutional in as far as they do not they are inconsistent with Section 12(1) and 35(2) of the Constitution. And the 35(2), which is more important in this aspect, relates to the rights of arrested persons, relates to the rights of detained persons, relates to the rights of those who have been accused. So the Constitutional Court then found that this was inconsistent in as far as it does not provide for the detained person to be brought before the court within the court days. Also, that the right to legal representation would have impacted in relation to what the provisions are. So they found this to be unconstitutional and inconsistent with the court. So in the next slide, we're just reiterating the two Constitutional Court judgments. And if we can go to the slide after all the background has been dealt with, and just to recap on the slide that deals with what the Constitutional Court had then indicated, just to recap what the minister have indicated, namely that since 2017, the department has been complying with the Constitutional Court order, because in that order, the Constitutional Court had then ordered that all people who have been arrested for purposes of deportation must be brought before court, which is the magistrate court, within 48 hours from the time of arrest, so that the magistrate court will then look at the lawfulness of the arrest, but also on the lawfulness of the detention. If the magistrate is then satisfied that indeed the arrest and the detention is lawful, then the magistrate will order that the arrested person be detained for purposes of deportation, and that they need to be deported within a period of 30 days. If the 30 days had lapsed before the deportation has occurred, the order had then requested that, or obligated an immigration officer to go back to the court and request an extension of the order that has been made, so that and then the court would then extend that period with another period to allow for the department to deport such an individual. So right after the 2023, in fact, after the 2017 judgment, the department had then developed an executive bill to deal or to give effect to the Constitutional Court order. But you will recall that most of the issues that then happened thereafter were ventilated in the 2023 judgment, but wherein the Concord then granted the extension that the then minister had requested in order to deal with this matter. So this bill was then introduced, sent to Parliament, and introduced by the then Minister of Home Affairs on the 5th of April 2014. And then the bill was then sent to the Portfolio Committee on Home Affairs to process. The Portfolio Committee on Home Affairs then published the bill for public participation process, and there were approximately 378 written submissions that were received by the Portfolio Committee. Of the 378 written submissions that were received, 32 were substantive in nature, in that they affected the provisions of the bill, and 346 were not substantive in nature. In the next slide, we are now starting to deal with what then happened at the Portfolio Committee meeting. Primarily, we just want to bring to the attention of the committee that there were certain issues that were before the Portfolio Committee, namely in relation to the fact that the provisions did not deal with Section 35(2) in its entirety, and that it was then incumbent on the Portfolio Committee to revise the text of the provision in order to encapsulate what appears in 35(2) of the Constitution, and that amendment was then carried by the Portfolio Committee. There were also issues then requiring that the Minister of Home Affairs be obligated to make regulations in order to assist immigration officers in exercising their discretion. This discretion follows the Constitutional Court order, wherein the Constitutional Court had then indicated that prior to detaining an individual, an immigration officer must determine whether it would be in the interest of justice to release such a person or otherwise. So then the bill was then revised to ensure that the Minister of Home Affairs make regulations to guide immigration officers on how to exercise this discretion and what is meant by interest of justice. Then when the matter was before the portfolio committee, these were the institutions or persons that have submitted written representation, and they also made oral representation during the meeting of the portfolio committee. In the next slide, we're just reiterating and reminding the select committee of the dates on which the Department of Home Affairs, together with the Parliamentary Legal Services, as well as the Office of the Chief State Law Advisor, on how they assisted the portfolio committee to deliberate and to process the bill. And on the 18th of March, the committee then adopted the motion of desirability and decided to proceed with this bill. With the bill was then dealt with on a clause by clause, and the report then was adopted on 22 July 2025. In the next categories of slide, we're just reminding or putting before the select committee the contents of the bill at a high level. And just to indicate that the bill seeks to amend the Immigration Act so as to revise the provisions relating to the arrest and detention of illegal foreigners for purposes of deportation, and to align these provisions in line with the constitutional principles, but in line with the constitutional court orders. In the next slide, we just dealing with the clause by clause, just at a high level, to indicate that when you look at the bill, clause 1 will insert a new subsection under clause 34, under section 34, and will also ensure that the Minister of Home Affairs then make regulations to deal with the interest of justice, but to guide immigration officers, as well as to ensure that the courts are also able to determine what the immigration officer would have considered at the time of making a decision whether or not the interest of justice permit the release of such an individual, and other considerations relating to the rights that flow to arrested and detained individuals as it relates to Section 35 of the Constitution. For instance, the right to legal representation, the right to be informed in a language that a person understands, the right to make representation, either written or oral, before the immigration officer, as well as before the court, and so on. Clause 2 will then, these are the rights that we were talking to in the next slide. Clause 2 is just a technical amendment. It just seeks to correct a mistake that we found in the text of the Immigration Act. So in the text, Chair, the word court in the Immigration Act, it's written with the capitalized C. However, when we look at the Magistrate Court Act and other pieces of legislation, the word court it's used with a lower cap. So we are just correcting that to ensure that we are aligned to the pieces of legislation. And then clause 3 will then deal with the short title and commencement of the bill once it has been promulgated, and also once the president has assented to and signed into law this bill. So in the next slide just reiterates what I have already indicated on the previous slide as it relates to clause 1. So, Chair, we are recommending that the Select Committee on Security and Justice note the presentation, but also note the introduction to the National Council of Provinces of the Immigration Amendment Bill by the Minister of Home Affairs, and for the Select Committee to then deal with the amendment bill as it deems fit, and in terms of the parliamentary processes. Thank you, Chair.
Thank you, Advocate Malakate, for taking us through the roadmap of this particular bill. It shows that it's been a process from 2017 till to date. We have noted issues that you have elaborated on judicial oversight and due processes and detention conditions, as well as national security and border control. And we have noted, as indicated as well by the minister, other issues that relates to human rights compliance and as well that has economic impact of immigration. So we want to thank you and we hope that you are still going to be on the line so that when members engage, you are able to respond to issues of clarity. And I like the fact that when you take us through the clauses, you are even indicating actually what is it that were omitted or edited on this bill, so that at least we are abreast that now you have fulfilled the mandate as given by the Concord outcome, that what needs to be done to ensure that human rights are upheld. We want to thank you, Tate Malakate. Now we would have a representation from State Law Advisor, Ms. Sarah Govenda. Over to you.
Good morning, Honourable Chairperson, and good morning to the Honourable Members and the Honourable Minister and all others present on the platform this morning. Chairperson, I'm Ms. Sarah Govender from the Office of the Chief State Law Advisor. Chairperson, we do not have a presentation this morning, but merely here to confirm the process that has followed thus far, which has been spoken about by Advocate Malakate, and we confirm that that has indeed been the process that has unfolded thus far. The Office of the Chief State Law Advisor has certified the Immigration Amendment Bill B8 of 2024, and which was then taken to the Portfolio Committee, and we have assisted the committee with giving effect to amendments which they deemed necessary. That has now resulted in the bill which is before the committee this morning, which is the Immigration Amendment Bill 8B of 2024. Chairperson, we once again reiterate that that bill is constitutionally sound. And Chairperson, with that being said, we as the Office of the Chief State Law Advisor are available to assist this Honourable Committee with the further processing of the bill. Thank you, Chair.
Thank you, and I think we are comforted by the fact that you are saying and affirming that this bill is constitutional sound. We would know as members of a parliament, one of our responsibilities is to uphold the constitution. So we hope that your certainty would actually make sure that we protect the rights of South Africans with regards to this bill. Now we would want to hand over to the Parliamentary Legal Advisor. I'm not sure who's going to be taking us through the presentation because we have two representations, Ms. Daksha Kassan and Ms. Clara Williams. Over to you, Parliamentary Legal Advisors.
Good morning, Chairperson. I'm Daksha Kassan. Together with me on this platform, I'm joined by my colleague, Ms. Clara Williams. We also don't have a formal presentation. We were asked to prepare any comment if needed. Both Ms. Williams and I were part of the Portfolio Committee process and assisted the committee in addressing public submissions and also in the drafting of any amendments that were forthcoming from the Portfolio Committee. At this point, we confirm that the process is unfolded as was presented by Advocate Malakate. We have nothing further to add, but are willing to still be here on the platform to answer any further questions that might arise, and will continue to assist this committee in processing the bill further. Thank you, Chairperson.
Thank you, Ms. Kassan. Now we would go to Gershwin on item number 3, of which is committee procedure to consider the Immigration Amendment Bill. Just take us note on what is the update so far, noting that all these presentations have been indicating that all the processes have been went through according to the regulations. So just indicate to date, Gershwin, in terms of the status quo, noting that our part now is to note what has happened by the NA and what needs to happen after this particular day today. Over to you, Keshwan.
Thank you, Chairperson. Yes, Chairperson, we've distributed the procedural advice, so members have that in their possession. In terms of the process, Chairperson, the National Assembly is considering the bill tomorrow, Thursday, the 11th. It will then be referred to the NCOP for concurrence and specifically to our committee. From that process, we will then advertise the bill for 3 weeks. I must just stress, Chair, that we've already started early with the application for funding for the processing of a bill. We will do this in all official languages in all provinces, and then 2 national papers, one in English and one in Afrikaans. We will also be advertising on Parliament's social media platforms and on its website. And we also use proxies such as the Parliamentary Monitoring Group, who will kindly assist us with flighting of those. And then, Chair, we would also want to use sign language, considering that this is the month for signing of one of our official languages, Chairperson. And so we want to introduce that in a video format, and we hope to get that off the ground as well. And then just in terms of the process, Chairperson, we from the date of publication, we provide 3 weeks deadline. We receive written correspondence. The committee assesses those correspondence and may then elect to have public hearings to clarify the process, or it may decide to proceed straight to the department to answer to the written correspondence. And then based on that, the committee will then deliberate further. It may propose amendments. And once we have concluded that process, the committee will then adopt a report with all of its all of the amendments that have been considered part of that report, and that will go to the National Council of Provinces for debate, Chairperson. Thank you.
Thank you, Gershwin, for the update. And I know that members have noted that so far the process is where, in terms of us fulfilling our mandate of ensuring that we take these matters to the public for public participation and public involvement. Members, now we are on item 4, of which is committee discussions. I would now note hands from members who would want to seek clarity or comment with regards to the presentation being given to us, and as well the remarks by the minister. Over to you, members. I'm noting hands on the platform. I have noted Honorable Phala. Any members? Honorable Mzamopili, you are noted. Honorable Mitupi, Honorable Kherik, Honorable Pito. Okay. I will start with Honorable Phala.
I'm trying to raise my hand. I don't know what's wrong with my gadget. I'm sorry, Sir Cliff.
Okay,
No.
you'll be the last one. You'll be the last one, Nkosi. With me on my side, I have the first member is Honorable Phala, and then it will be Honorable Billy, then Honorable Kherik, and then Honorable Pito Nowe. I've noted Honorable Midupi. I'm not sure if the hand has automatically been removed or what. Honorable Midupi?
No, I was on the third position, Chairperson.
Okay.
I was the third.
Okay. That's fine. Then members will come accordingly. You are the third one, Honorable Midupi.
Yes, correct, Chair.
Yeah.
You
So
are right.
you'll come after Honorable Billy. Over to you, Ntate Phala.
Thank you, Chair, and good morning to the Minister, and good morning, honorable members, and good morning to the officials on the platform. Let me start by appreciating the presentation, Chair, and also note the Minister's remarks the minister said this is part of the reform which is underway. It's really appreciated, Minister, that this is a part of the transformation which is underway, and we are working together on these issues. Chair, I just want to know what Advocate Malagate indicated here. And I must appreciate really this a very short and precise presentation. And my concern, Chair, is that the bill, as Advocate Governor says here, said that the bill is constitutional sound. If the bill is constitutional sound, it must be in line with Section 198 of the Constitution, which is which speaks about issues of national security. And Section 198 clearly says the national security must reflect the resolve of South Africans and individuals and a nation to live as equals, to live in peace and harmony. And what I'm saying here, Chairperson, is that the bill must in no way violate the national security of our country. We are under severe pressure as a nation on issues of immigration. And as the officials here says, it is constitutional sound. It must really be in constant of those things which we are concerned about. So this is what I wanted to mention, Chair, and thank you very much. We really appreciate the manner in which the presentation was presented by Advocate Malagate, and we say what wonderful. We'll look forward to all other processes and add our, and apply our minds, particularly on issues of security, which South Africans are crying about. Thank you, Chair.
Thank you, Honorable Phala. Honorable Mzamo.
Thank you, Chair. With your permission, may I please switch off the video? It's completely dark in my office, and I'm not sure if you can see me.
We can see you, but permission is granted. You can continue.
Thank you, Chair.
You are muted, Billy. You are muted.
Oh, sorry, I switched off the wrong thing. Okay. I was saying, Chairperson, let me also welcome the presentation that has been done by the department, but also welcome the initiative that's being taken to try and provide clarity into how these processes are to unfold. I think this is certainly overdue. It is something that should have been wrapped up a while ago so that it could be able to assist our courts in the entire process of deportation and managing that space. So, I think it is something that is very much needed. I think the minister did mention that this is just one aspect of many other things that we need to get right, that we need to fix, which is 100% correct. This is just a small part of a space that needs to be dealt with, but there are many other spaces which needs to be addressed. I think the minister spoke about the technological reforms that are ongoing in the department, that we can all see the effort that's being put in digitizing the department. And I think part of what is being dealt with in this bill will be very much dealt swiftly if those reforms could also be sped up so that there is better finger management systems in place, which should form part of the broader reforms that the minister speaks of. So this bill alone is not going to solve the problems. I mean, I recently visited the Pinetown Magistrate Court, which is one of the busiest courts in Durban, in KwaZulu-Natal, just last week. And the number of illegal immigrants that is being arrested, but also released at the same time, is shocking because, again, there isn't any clear process that is to be followed when those operations are done between the Metro Police in the city and the police, and there isn't any involvement of other stakeholders such as the immigration or home affairs to help with that process. So I think this is much needed. I would want maybe to hear in as far as what is the timelines in getting this to the finish line. I did hear that it's going to take at least 3 weeks once it's been processed and it's out there for comments. But I think there should be some urgency into getting this done. But also the white paper that was mentioned, which is part of the process also to deal effectively with deportation. That what is also the process or the timelines to also complete that so that we can be able to get all of these processes being concluded. We get the technological reforms concluded. We get our legislation. All of these things, once they all align and work hand in hand, there should be a significant improvement into how illegal immigration is dealt with, the deportation is dealt with, people coming in and out of our country, and so on. Perhaps maybe a comment on that. But in overall, Chairperson, I think this is a much needed step. It's just unfortunate that it has taken this long to get it really going. But I think we must commend the Minister for this movement that we are seeing. Thank you, Chair.
Thank you, Honorable Mzamo. Honorable Midupi.
Thank you very much, Honorable Chair. Honorable Chairperson, can I be maybe afforded an apology to switch off my camera, please, Chair?
It's granted.
Oh, thank you very much, Chairperson. Hey, I've got a touch of flu, Chairperson. I don't want to be seen sneezing on the screens.
Okay.
Chairperson, thank you very much, Chair. Let me also join my colleagues in appreciating this progressive initiative by the department. However, Chair, this come at a time when I had an oversight in the 2 magistrate courts in the area that I come from in the Northwest, which is Oster and Swartregens Magistrate Court. And one of the discussions that we had with the 2 magistrates was the workload, the caseload that they were experiencing in terms of illegal immigrants. And indeed, I should think this bill will help us and will help alleviating the challenges that are there. And Chairperson, I've got just 2 questions to the department. And it is just a direct question that what are the implications of the court ruling if the court do not have capacity to be able to see immigration detainees on the first available court day? And what are the provision needs to be made for the detainees if Department of Home Affairs is not is unable to get them for court in time. So these are the two questions from my side, Honorable Chair.
Thank you, Honorable Kim. I hope that the Malakate was noted those two questions that are direct, as well as questions from Honorable P. Honorable Gerik.
Chairperson and members of the Department of Home Affairs and colleagues, good morning. Chair, unfortunately, I am not going to join the choir of congratulations because why these amendments of this bill has been taken by a human rights organization to the Constitutional Court for amendments. So it is not automatic that the Department of Home Affairs effected the amendments. That's the first point. The second point is that over and above the fact that this is coming from 2017, if I'm correct, it is rather disturbing for an amendment to take so long. You know, it's a very long time. It's almost 8 years that we only arrive here now. The third point is that we are a constitutional democracy. This department is a critical strategic department, particularly when it comes to the constitutional rights of the citizens of South Africa and even the immigrants. It means now that this department should be ready at all times to heed the call of constitutionalism. You know, we are 30 years in our democratic dispensation and we're still dealing with apartheid laws to be corrected. It is a shame. It is just a blatant shame on all of us that we still deal with this. We are a constitutional democracy. All our laws should have been brought in accordance with our democratic constitution already after 30 years. It brings me to the following point, Chairperson. You know, this is, with all due respect, and you can call me to order, this is just a waste of time, this meeting this morning, to deal with amendments that were, that the Constitutional Court has compelled the department to oblige to. Now, I'm asking now, when I say this, since this department is such a critical strategic department when it comes to constitutional issues, can I ask that, if anybody can answer me, does this department have a compliance section or a compliance department? And are there a team, is there a team that deals with combing, scrutinizing through the particular mandate of this department to bring it in alignment in accordance with the Constitution so that we avoid, so that we are spared this shameful thing that we are dealing here with this morning? Because all our departments should have already complied to the requirements, legislative requirements in terms of our Constitution. We should not deal with this any longer. The other day, we have gone through the Constitution, all departments. We found that there are still 1,800 pieces of apartheid legislation that has not been corrected. Now, it cannot be allowed in the Department of Home Affairs because this department is too critical, too important, and too strategic when it comes to the rights, the birth rights, the marriage rights, and every other right pertaining to people living in South Africa. So I'm asking, if there's no compliance, if there's a compliance department, can we beef up that compliance department so that we make sure that all types of legislations, the reason why we need to bring it into alignment, Chairperson, is to save our nation the unnecessary processes, the unnecessary type of discrimination that they still suffer because of apartheid legislation. Thank you, Chairperson.
Thank you, Honorable Gerik. I was not going to call you to order. It's your privilege as the Member of Parliament to raise issues according to how it should or befitting. As long as you don't insult, you have never insulted anyone. However, I think you must appreciate as well that members on the platform are saying that they are appreciating the fact that this matter has been brought in this meeting to outline the processes that have unfolded. And I think Honorable Bill as well has alluded on the fact that this bill has been overdue. And that actually makes us light and feel that it is important that this matter has been brought here to do our part as well as the Select Committee, the NCOP. But other matters will be responded to by those that you have questioned, more especially on the issue of the if we have capabilities on compliance in our department. I think it is important to be responded to Ntate Makate, so that we know whether for us to be here, it is on the basis that we lack that human capital that can actually advise when these processes are taken through, so that we don't get to a point where it's up until 8 years that you are dealing with a matter that you could have dealt with within 2 years or a year. But on other matters, it's what we appreciate your critique, comment that you feel that we are wasting time. It's noted, and there's nothing wrong that you have said. Now, Honorable Noe.
Thank you, Chairperson. You have dealt with that issue of Honorable Gerike. There's no chorus here. It's members doing their due diligence. There's no choir. I don't think that was a correct word to use by a member, that there's a choir. We have to appreciate what has been presented to us. I think all of us, we are executing our responsibilities before us. Chair, mine are on two aspects. Firstly, I want to join members who have appreciated and who have also conveyed the committee's greetings to everyone on the platform, beginning with the Minister and the inter-region members of the committee. Chair, number one issue that I would like to check clarity on, the bill, as it were, it deals with detention and deportation of underlying illegal immigrants. In other words, these people will have already been determined that they are in the country illegally. So while I'm not against the issue of compliance with the Constitution, but one aspect that I would like to check is, as South Africans, if we go to court and we were found to have, if you are found guilty of having breached the law, there is an expectation or a clause that, or a provision that you may be expected to pay the cost of the court. Now, here we are dealing with illegal immigrants. And I would like to check whether the legislators or the drafters of the amendments also have considered that we incur costs going through what an illegal person will have cost the country. Is that part also considered, that either the immigrant will then have to be expected to pay the costs of the court and all other processes, or his or her country will be expected, or is that something that can be considered? This further, Chair, lastly, it brings me to the influx of the immigrants, which we are actually seems to be having a challenge to deal with. Is this not clause also not going to lead us, while complying with the Constitution, but then allowing influx of foreigners that we are currently challenged to deal with, And I'm saying this, Chair, with a heavy heart, as Honorable Mudupi has said. Coming from the constituency period, we are now sitting with illegal immigrants, some of them who are owning these spaza shops, and South Africans are supposed to be considered for the benefit of the money that they have been given to boost their economic well-being. But because of illegal immigrants that are also owning, who have applied for registration of spaza shop, and this is delaying. So I'm looking at, Chair, the issue of illegal immigrants in totality in terms of this provision that needs to be now inserted in the Act. Those are my two questions, Chair. Thank you very much.
Thank you, Honorable Pito, and thank you as well for emphasizing on correcting Honorable Gerik. I think as this committee, we've been very disciplined on how to, use our languages when we speak with each other or when we are on the platform, because we don't want to act as if we are TikTok social media people. And I think it is important that we maintain that standard because we take our...
Now, Chairperson, on a point of order, Chair.
Over to you,
I have always respected this committee. There's no reason to capitalize on what I've said. I've spoken my mind. Yes, I haven't transgressed any rule, and no member must be allowed to capitalize on what another member has said. I think this is the way that you should be dealing with this. There was no
Chair,
reason
there's
to
no
come
order
for
there.
Honorable Pitso
Don't
to
allow
come in to say
Honorable
that there's no
Gerik.
choir here. He is out of order. Thank you.
Your order is not sustained, but I think let's maintain the discipline. We've been speaking with one another, not using any other languages. That's it. Honorable members, let me get to Honorable Nonkonyani. Over to you.
Chair and honorable members, good morning. And I must also join all the honorable members in welcoming the presentation, Chair. Mine is two crisp questions for clarity. And the first one is the issue of language. I heard the presenter saying those illegal immigrants will have a right to use the language of their choice. You, Chair, and honorable members would recall when we were on oversight in the Popo, this issue also cropped up because some illegal immigrants, because they want to be detained in South Africa for quite a long time to enjoy the rights of all the detainees by actually insisting that interpreters be received. And it has cropped up in many cases that they would use dialect. For instance, in the Eastern Cape, where I come from, isiXhosa language, which is predominantly being used in the official language. There are dialects. Simpondo, that is not official my language. Isinkele, Isibhaca, I may mention many of them. I would love when that member respond to this question of official or of language of their choice, whether it would not be prudent to restrict that to official language, not only language of their choice, as they may actually insist on the language that very few, if at all, people as Honorable Gerik may also say that would like to use Kwe or the Khoisan language, for instance, which is, as of now, it is not an official language, and it is a language that is spoken by very, very few of our own people in South Africa. That's one thing. Secondly, Chair, is the issue of the regulation, which I again welcome the issue of the regulations. And I take it, just want not to assume that those regulations, those draft regulations will be circulated for public comments, and after that, of course, will be tabled to us in Parliament. I hope so. And with that, Chair, I would therefore move that we really accept the presentation with appreciation and with all the processes that have been set out by all the presenters. I thank you, Chair.
Thank you, Honorable Nonkonyane. We have noted a few questions, but mostly it's comments of appreciating the process till to date. And I think, members, there's a lesson to be learned that in our time, we must not wait for bills to be taken so long, taking in consideration what Honorable Gerik is cancelling, that perhaps we need to as well look at the issue of capabilities in terms of legal minds in our departments as we deal with these issues, because we know that most of the time when matters are being brought back from the Concord, it's on the basis of inconsistency on all constitutional matters. So I think it is important that we take that counsel and try to lobby and advocate as we meet with other departments to ensure that we don't go back and forth dealing with issues that actually impedes to the security of the country, as Honorable Phala could have said. Because really, when you read this immigration bill, you are able to appreciate that this was supposed to be long done. We would have not been where we are in terms of illegal immigrations that are actually contributing to social issues in our areas. So with that being said, I want to hand over to Ntate Malekate from the department to respond on other issues, but as well, feel free to indicate where you think that you short of responses you can go through and get those particular responses, more especially those that you think that they need you to go and check with the other departments on how these matters will be dealt with. Over to you, Ntate Malekate.
Yeah, thank you, Chair, and thank you to the honorable members of the Select Committee for the questions. There are certain questions, Chair, that I would like to defer to the Director General so that in the next minute he can then be able to take them through or respond to them. And just to indicate from Honorable Billy on the question of timelines to finish the work, I think the Secretariat had indicated the timelines that the Select Committee would need to deal with. So I think I can leave it at there. But just to reiterate the fact that from the department side, we are going to be available to assist the Select Committee in processing this bill further. I think with relation to the timeline relating to the work that needs to be done on the white paper, what we can indicate is that the department is currently seized in developing the amended white paper. And we anticipate that before the end of this financial year, we should have finalized the work. In fact, that is part of our annual performance target that we need to deal with it. And I think also what the minister had said earlier on, that we are indeed prioritizing this to deal with it as soon as possible. And thereafter we'll then commence with the issues relating to developing the bill to give effect to what the white paper would have indicated. Chair, with Honorable Medupi's questions, and there are two in nature, but it relates to the court processes and overload of the cases relating to illegal migration that the magistracy faced, and what would be the impact thereof. Chair, just to how to respond to Honorable Medupi is that the department, together with the Department of Justice and Constitutional Development, continue to engage on these matters in order to ensure that there is a smooth handling of the cases in relation to the times, but also in relation to the capacity within the court process. But just to indicate, Chair, that the department obviously is enjoined to ensure that it complies with both the Constitution but also the Constitutional Court order. And in this respect, the department is obligated to, once they have arrested a person for purposes of deportation, that they would need to bring this person within 48 hours. And if the 48 hours falls outside of the court order of the court dates, immediately after the expiry of the 48 hours. But we ensure that we deal with it, and we continue to speak to the Department of Justice and Constitutional Development, as well as the judiciary, on how best to deal with these matters. And on the question from Honorable Ferrick relating to whether or not the department has a compliance unit, I think I will defer this to the Director General, and I will just ensure that the Director General in the next select committee meeting deals with it, but I'll place it before him so that he will be able to respond to this. Chair, with Honorable Noe, I think most of the questions that you are raising, Honorable, they are quite pertinent, and there are issues that this bill does not seek to deal with, but we anticipate that when we deal with the white paper, the amendment, the work that we are doing under some of these issues should be carried there, and that the white paper should then have some form or way to deal with the matters, so that we are conclusive in dealing with migration issues. But I have taken note of the questions that you have raised, and I will share with our policy unit that assists with developing the white paper further, so that the issues that you have raised, Honorable, can then be carried. With the Honorable Nkosi Nonkonyane's questions, the issue of language, just to place before Honorable Nkosi that in terms of the Constitution itself, if you look under Section 35(2), it does obligate or grant a right to an arrested person or detained person or accused person, that such a person, although it is not the language of his or her choice, the Constitution requires that he or she must be explained of his or her rights in a language that they understand. So if you look at the bill, the provision of the bill, we have placed 2-3 words that we think would deal with the matter that you are raising. We're saying, if it is practicable and it's readily available, then we would be able to provide or the explanation or inform the arrested person in the language that they understand. But constitutionally, we are enjoined to ensure that we do our processes and explain our processes in the language that the individual understands. And we perhaps, just to indicate that we were, during the portfolio committee meeting, the portfolio committee was also seized with this issue on whether or not it is possible to restrict that to the official languages of the Republic. But if you look at the constitutional jurisprudence, as well as the Constitution itself, it sort of obligates the state or for the department to explain in the language that the person understands. And indeed, from the department side, we do have language services, interpretation services, although they are not they are dealt with at head office level, but they are available for immigration officers. And yes, Honorable Nkos, once the minister, once the department has developed the regulations that are attendant to this bill, the minister would then publish that for public participation processes before the minister makes the final decision on the regulation. So they would be subjected to the public participation processes. Thank you, Chair.
Thank you, Tate Malakate. Can we have the DG responding to other issues as indicated by yourself? DG Home Affairs.
Chair.
Yes, sir.
My apologies for coming in. We forgot to indicate earlier on that the DG is seized with somewhere and he's not available, but we'll make sure that the questions that have been raised, that folks within his space, that in the next select committee meeting, that the DG then deals with them.
Okay, what we normally do, noting that, and I think it was not submitted to us that he won't be here. What needs to happen is that on issues that you felt that it was for the DG to respond on, can you make submission within 14 days on those particular issues? Noting as well the question by Honorable Gerik on issue of legal capacity in the department. If you would need to take us abreast and in confidence as you did with other questions, it will be appreciated.
Chair, we will do so through
Okay.
the office of the DG.
Okay. No, thank you. On my side, let me appreciate the responses from Home Affairs and as well what has been given as affirmation or confirmation by legal departments and as well the legal, the state law, that we are satisfied on our side as members of parliament that as we'll be taking this process of public participation, we'll make sure that we comply with all the requisite by law that needs to happen with regards to amendment of the bill without leaving anyone behind. We want to thank you and we want to release you on the platform so that we can deal with item number 5 as members.
Thank you, Chair.
Thank you, Chair.
Thank you, Ms. Govenda.
Thank you, Chairperson.
Thank you, Chair. I'm just checking if you're releasing me as well.
No,
It's the
sorry, sorry, Minister. Actually, I have omitted yourself thinking that you are busy, as you said, but we want to thank you for your availability as well as and your political leadership. And I think you have noted what Honorable Pala could have said with regards to this issue and ensuring that we make sure that we uphold to Section 198 of the Constitution that speaks about national security. And I want to indicate to you that indeed, when I was reading these documents, I felt that, you know, Home Affairs, I think it's an under naming of this department, because this department carries us from birth to death. And giving it a Home Affairs issue, we didn't do justice to it, because you can see on daily basis, if you deal with issues of Home Affairs, then you deal with other issues that seem to be the crisis in our country. We want to thank you for your commitment, and we hope that you would make sure that the DG respond to issues that we said that they must do that within 14 working days on issues that were asked by other members.
No, thank you, Chair. That's noted.
All
Thank
right.
you. Thank you.
Thank
Bye-bye.
Members, we are on item number 5 in terms of consideration and adoption of our minutes. We'll start with minutes of the 25th, 07/16, when you engaged with the Magistrate Commission. I would now note hands for adoption or omissions or additions with regards to these minutes of the 25th, 07/16.
Chair, my hand is up. Hey.
Over to you, Honorable Nonkonyane. I haven't seen any hand, but over to you. Let me just start by checking on the platform. Yeah. Okay. Yeah, it was not yet up, but over to you, sir.
Chair and honorable members, thank to the Secretariat. I did read the minutes, Chair, and they do really reflect correctly the proceedings of that meeting, and I accordingly move for its adoption.
Okay, thank you, Honorable Nonkonyane. Honorable Nonkonyane, colleagues, moves for the adoption of these minutes as a true reflection. Any member who have a dissenting view or the seconder of these particular minutes? I'm noting hands, members. Honorable Kherik?
Yes, Chair, I second so. Thank you.
Thank you, Honorable Kherik. Minutes have been duly adopted. Now we go to item 5B of minutes of the 25th, 07/23. Reports and minutes to be adopted. Members, we got these minutes before in terms of what could have transpired on that day. And now I would want to note members for adoption and seconding of these particular minutes.
Chair,
Honorable Nonkonyane?
my hand is also up. I move again, Chair, that the minutes be adopted as a true reflection of our proceeding on that day. Thank you.
Thank you, Honorable Nonkonyane, for adoption of the minutes. Honorable Peter Noe?
Thank you, Chair. I raise my hand to second Honorable Nonkonyane for the adoption of the minutes. Thank you.
Thank you, Honorable Noe. The minutes have been duly seconded by yourself, and these minutes have been duly adopted and seconded. Now we are on item number 6, of which is closure and way forward. The way forward is clear, members would await for the publication of the public participation process, where we would go for our own public hearings as the select committee to ensure that we collect the interest and the views of our people from our provinces in terms of this particular bill and ensure that we effect them. Honorable Peter, is it a legacy hand or a new hand?
It's a new hand, Chair, with your permission before you close. I was just checking with the research team. I thought of asking this from Advocate Malakat, but nothing is lost. The 300 and so of the last presentation, or what is that? Submissions by those stated organizations. I don't know whether will it be asking too much, or will it be possible perhaps just to obtain, even if it's a summarized document as to which areas or what matters will have those organizations perhaps raised during the initial submission. Thank you, Chair.
Okay, it's noted. I think we can just write a letter to them for request with regards to those details as being raised by yourself. Gershwin, I hope you have noted what Honorable Noe was requesting, that it will be of importance if we get from the department. I think it's something that we can do from our side in terms of writing this letter. Yeah, you have actually disturbed my thought, but it's fine. Members, I want to just indicate to yourself, as I said, that we'll await that time when the advert will be out for us to go for public hearing, so that we ensure that we do what we have to do on our side as the select committee to collect all the issues that needs to be taken through for this amendment bill to be adopted. And then what is nice about what we did as the select committee is to ensure that one of the advert must be for those who cannot hear, those who are deaf society, to actually get the message across. Because with the provisions that we had, it was only about communicating with all the officials' language, not including the sign language. So the inclusion of sign language will be the first from our side as the select committee to explore in terms of this particular advert. And we hope that all of us, as I know that we are a committed team, will be there when we do this public hearing, so that when that time of adoption comes, we don't want to take it back or, try to behave as if we were not part of the process. So with that being said, members, I declare this meeting officially adjourned and want to thank you for your maximum participation as usual.
Chair,
Honorable Nonkonya.
just off record, and thank you very much. Honorable Billy is actually party's colors are actually showing when you are speaking. I don't.
It's heritage month. We cover every vote. Thank you. On that lighter note, we cover every vote.
I was asking myself if this is true, Nkosi. How you are confirming what I've been suspecting.
No, the meeting is officially adjourned, members.
You look good on blue, Chairperson. You look good on
Yo. Guys, you want 10 years? So for 10 years. The meeting is adjourned, members. Thank you.
Bye.
Thank you. Bye.